Alicia Powell with the Gateway Pundit. January 6 cases are the most important free speech cases in American history. We are watching the First Amendment get decimated by the federal judges and who allow rigged jurors and recycled jurors to determine the fate of January 6 defendants. These defendants have committed no violent crimes often, yet they're sitting in prison facing the same time a murderer does. Enrique Tarrio was sentenced 22 years in prison, Joe Biggs 17 years, Ethan Nordine 18 years, Zachary Rail 15 years. All they did was walk into the Capitol building, take a few selfies, and leave. And for that, they have been now looking at spending decades of their life behind bars for thought crimes. Treated like they've committed some massacre with seditious conspiracy charges. Congress is across the street from the federal courthouse doing jack shit about any of this. Today we're going to be talking with a defense attorney, Norm Pattis. Norm represents many high-profile defendants, including Alex Jones in the Sandy Hook case, InfoWars host Owen Schroyer, Proud Boys members Joseph Biggs, Zachary Rail, who were just found guilty of seditious conspiracy and given the highest sentences than any J6 defendant. Norman, thank you for joining us today.
Yeah, thanks for having me.
It's a pleasure to get a chance to stop and sit down and talk with you. I see you in the courtroom pretty frequently. I understand during trial there's a lot you can't discuss, and you face being barred for even saying too much. In my perspective, watching these trials go along, why don't you begin in talking about what you can about how it looks like defense attorneys are barred from actually putting up a good defense. I've received from another attorney a Lemoyne motion, a litany of things you can't talk about during trial. Do you feel like the judge is kind of crippling your defense? Basically limited your what you can say, when you can talk to media and such?
Well, every case faces those problems. I mean, it's trial judge's responsibility to make sure that both sides get a fair trial. It often feels like you've got prosecutors and the judge on the same team, and it's awfully frustrating. But a judge gets to make decisions about what is relevant to a case, what's material, in other words, what things can and cannot be brought to the attention of the jury. Now, what's frustrating is, when you're indicted and held out to the world to have broken the law, your reputation is destroyed. And at that moment, the court wants to say to many defense lawyers, you can't speak about the government's case beyond basic formalities. You can deny guilt, you can assert a theory of the case, but you can't attack the government's witnesses. We see this with respect to efforts to gag Donald Trump in his cases. I like to remind judges that the Sixth Amendment right to a fair trial belongs to defendants, not to the government. The Sixth Amendment doesn't say the government shall have a right to a fair trial. It says the accused does. And my view is the accused should be able to strike back by means fair and foul. I'm not a judge. Judges don't see it that way. They take their inherent supervisory authority to see that justice is done quite seriously. And I think that the result is the playing field seems to have favored. In the Proud Boys cases, there were some really shocking developments. We sought to challenge the extent, the government maintained that the Proud Boys had a plan to disrupt the government, to use force, to engage this disruption of the government. The jury bought it. Now, it's important to remember that the government's primary prosecutor giving the closing argument, Connor Mulrow, argued that there need not be a plan to find them guilty. It could have been a conspiracy, an instantaneous understanding at the barricades. But never mind. This was the government.
Well, I wanted to start off, I didn't properly introduce you. Norm, you represent Alex Jones on the Sandy Hook trial, Owen Schroyer, who's currently in solitary confinement because of this J6 inquisition against the First Amendment, basically, is how I see it, and many of us do. Also, the Proud Boys, Joe Biggs, Zachary Rail, and Jake Lang. And that is you can provide quite a bit of insight and more than the average on all of the workings of this courtroom. It seems like everything that's happening is quite illegal. I mean, when you go back to the Proud Boys trial, how often is it do you see this sort of litmus test that Judge Kelly basically tainted the jury with, asking if they support Black Lives Matter, Antifa, and attended the Women's March? Then they also would add that the Proud Boys are a group of white supremacists, and then they get a rubber stamp to sit on the jury. Is that common?
Well,
Is this
no,
illegal?
no, no, no. That combines a number of factors into one sandwich. I mean, let's break this up into bite-sized pieces. But first, let me. I was starting to say in the Proud Boys case, you'd asked a general question about prohibitions about what can be said and not. In this trial I've had, in which we had sealed hearings during the trial, and these sealed hearings were about confidential informants or confidential human sources. One of our defenses was there was no plan. If there were, the government confidential informants would have heard about it, told the FBI, and we would have seen those witnesses. And so we had to fight for the right to put on any of this information in the presence of the jury, and we won a limited right to do so. But there were hearings that I'm barred from talking about still. And I've been convinced in the course of the Proud Boys trial that there is a vast infrastructure of confidential human sources managed by the Justice Department that has infiltrated the right and is part of the government's weaponization of the Justice Department against dissent, this time dissent from the right. And it reminded me very much of what obtained during the 1970s when the Church Commission, or Church Committee rather, the Senate's Church Committee, discovered the extent to which the Justice Department the left. And I wonder where all the patriots are now. It's wrong for the government to harass or single out people on the basis of their political views. I think it happened here. I think it's happening now. I think it's shocking. I see members of the FBI and the Justice Department stonewalling House investigating committees. I wonder where the contempt power is there. So I frankly lost an enormous amount of respect and confidence in the government. I view Merrick Garland as a cancer on the American body politic, and I think his transformation of the Justice Department into a thugs club is a clear and present danger to civil liberties in the United States.
When have you seen this type of prosecution for speech crimes? I mean, 22 years for Enrique Tarrio, 17 and 15 for your clients, Zachary Rail and Joseph Biggs, Owen Schroyer sitting in solitary confinement because of COVID. And of course, look at what happened to Alex Jones. And you risked being disbarred. What you can tell us about that after. But first question is, in your years as an attorney, have you ever had to deal with this sort of litigation for speech crimes? And would you characterize this as speech crimes?
They're very different cases. So in the case of the January 6th case, I simply don't believe there was a coup. I believe there were people who had gone to the Capitol to petition for the redress of grievance, a right protected under the First Amendment. They went to speak out, a right protected under the First Amendment, and they went peaceably to assemble, a right protected by the First Amendment. The testimony at trial was at one point the crowd snapped. Broke out. One of the government's witnesses testified it reminded him very much of what he'd seen at food riots when he was in the service in Afghanistan. Throw a candy bar into a crowd and watch all hell break loose. Well, I think what happened on January 6th is agitated people wound one another up, and before you know it, a riot ensued, and there was some violence there. Let's be clear. But what the government did to the Proud Boys was chilling in the extreme. It went through all of their text messages, their telegram messages, their communications, and it took speech that was otherwise protected, speech they otherwise had any right to utter, every right to utter, and held that this was circumstantial evidence of their intent to engage in insurrection. An insurrection, seditious conspiracy, the legal definition of that is agreeing to use force against the authority of the United States government. So they made the Proud Boys into seditious conspirators by criminalizing their speech and using that speech to explain a riot. And that would be much like saying at a soccer game, if a crowd erupted, that all the speech, all the hatred of the other team that was expressed in the days and weeks prior to the match were proof that when people went to the stadium, they went with the intent to engage in it. It is true. Now, I understand the jury found otherwise, and that's what the appellate courts are for. As to the question of jury selection, Alicia, that I've never seen anything like the jury selection we had in the Proud Boys case. Normally, in a federal case, it takes a day, maybe a couple if it's a really complicated case with explosive facts to pick a jury. In this case, it took 12 days to pick the jury. Jurors had questionnaires, and they were asked a series of questions. Among them, were they familiar with the Proud Boys? Were they familiar with Antifa? What rallies had they attended? And what we found over the course of that 12 days is that many of these jurors had a negative impression of the Proud Boys. They didn't have a negative impression of Antifa. And many of them either themselves or had attended or had friends who did attend rallies that would be leftward leaning rallies. Not one attended a Stop the Steal rally. We tried to challenge these people as having associations that would make them inclined to not be fair and impartial to the Proud Boys. Those jurors said they could put their feelings aside and be fair and impartial. They could, in fact, be fair and impartial. We had moved for a change of venue. We'd asked that the case be tried outside the District of Columbia. That was denied. We challenged many of the jurors. That those challenges were more often than not denied. So we ended up with a jury that very much felt like a DC jury. And let's face it, DC is a unique territory in the United States. It's the only territory in the country that is specified by the federal Constitution to be federal land. There's that little block of land was where the capital is located, and it's there so it won't fall under the influence of any particular state. It's supposed to be independent, but what it's become is a company town, the capital of the deep state and the residence of those who serve the deep state. And so it felt very much like we were strangers in a strange land. I suspect we would have had different verdicts if we tried the case, let's say, in Texas, Florida, Tennessee, Alabama, Georgia, maybe just about anywhere other than New York City and California.
Well, it's remarkable that Congress, the U.S. Capitol building, is practically across the street from the courthouse. And it seems that if there's any avenue to relocate these trials, it would be in Congress's plenary power, maybe to impeach the judges, but to relocate, pass legislation to relocate these trials, perhaps. And now there's been a couple of defense attorneys, including your colleague Stephen Metcalf, that's sounding the alarm on the fact that these jurors are being recycled. I sat and watched jurors in Zachary Lamb's jury selection state that they were in the courthouse last week for a different trial, were struck down and were returned the following week to be seated on the Alam's jury. And you said to you, I approached you about this during Owen Schroeder's sentencing. You said to look into the law and see if that's legal, and it's not, according to any search you do on Google. Are you aware of this sort of thing? And what is your analysis of this?
It used to be, I'm not aware of the federal law, and that I'll be candid with you. I mean, in state court in Connecticut, for example, my primary jurisdiction, jurors used to be called for 30 days, and they could be rejected any number of times before they were set. What I understood had happened in the Metcalf case is that jurors were accepted to serve on one case, and then they came shortly thereafter to serve on another. That would be highly unusual. So I don't know if DC has a rule that permits people to be summoned to the courthouse for an extended period of time, whether there's a rule that prohibits them from being called multiple periods of time within a short time frame. I think it's odd and troubling, and you get the impression that they just don't have enough people to go around. And I'd be bothered by learning that my jurors were rejected because they could not be fair and impartial in a J6 case last week, and now they're called back to try another.
It all seems legal, and now the government coming back with asking for even longer sentences for these defendants.
Let's talk about that.
Yes, please.
That's the problem of the unscrupulous merchant. Let's talk about what happened in the Proud Boys case. The government got convictions on most of the counts it sought. I think 5 of the 9. There was an acquittal on one and no verdict as to some, and the court dismissed them. So the way federal sentencing guidelines, it's a massive cookbook that assigns a numerical value to an offense and then adds or subtracts points to the value of that offense based on so-called offense characteristics or defendants' characteristics. A court officer prepares what's called a pre-sentence report and makes a recommendation to the judge about what an appropriate sentence would be. And then the parties are free to make their own assessment of the guidelines. And at a sentencing hearing, the court adopts what facts it finds and imposes the sentence it thinks is appropriate. In the Biggs case, for example, or Rel, the pre-sentence report recommended a sentence in the 8 to 10. That's what the professionals thought, a candid evaluation of the file. The government sought sentences in the 30 to 32, 33-year range. I called one of the prosecutors up when I saw their memoir. I said, "Are you guys serious about this? This is insane." "Oh, we're serious." So they came out swinging, and they asked the judge for 30-some years. Now, the judge gave sentences in excess of what the pre-trial services officers, the pre-sentence investigator officers recommended, and basically gave the government half of what it wanted. And I noticed this tendency with Judge Kelly, who halfway Kelly, he meets the government halfway. A presumptively reasonable sentence for Joe Biggs would have been 8 to 10 years. That's what the pre-sentence report called for that. The government asked for 30. Kelly gave the government half of what it wanted, but 70% more than what the government or what the pre-sentence officer reported. And and I wasn't going to act thankful for that. I mean, consider the following analogy: you own a hardware store. You've got a hammer. It's $10. You put it on the shelf for 30, and somebody comes in and you say, "I'll give it to you for half off, $17, $15. Is the person supposed to thank you for paying more than the hammer is worth? No. Similarly, when we filed our notices of appeal, the government now struck back and filed cross motions to appeal, and they want to say the sentences are too low. I think what they're trying to do is manipulate us into avoiding challenging the sentencing by saying, by getting us to defend Judge Kelly's decision. I'll do no such thing. I think a trial tax was imposed in this case. Long ago, in the summer of 2022, maybe in the fall of 2022, not that long ago, but it feels that way after this year, the government sent a letter out offering pleas to the guys in the range of 7 to 8 years. And that, in my view, was what justice looked like to the government a year before the verdict. What changed afterwards? The guys went to trial. They fought. They held the government to the burden of proof. And for this, the government sought to have their sentences enhanced, to have them declared to be terrorists. When did it become a terrorist act to demand your right to a fair trial? When did it become a terrorist act to say, I didn't engage in insurrection? Prove it if you can. And if you do, I shouldn't be penalized for going to trial. So, many people will say there was no trial tax imposed in this case. Bullshit, I say. This was not they weren't offered a discount for offering to go to trial. They were offered a just outcome prior to trial. And when they lost, the government pouted. And the government sought to throw a 30-year book at him. And when it didn't get that, at sentencing, it now has filed the notice of appeal. It's bad. It's a bad look.
I'd like for
and it's all, and its intention, in my view, is to silence dissent prior to 2024. People are afraid to go out to protest because if some hothead 2 blocks away throws a Molotov cocktail and you're not a member of Antifa or BLM, or in which case that's social justice protesting in a mostly peaceful manner. If you're with a crowd and you're on the right and you do that, are you going to get charged with seditious conspiracy because of the emails you wrote 2 and 3 weeks ago?
I don't know if I'm texting a friend about the coup d'etat of the U.S. government when Biden stole the election and used say he stole the election. Is that thought crime? Is that a part of a seditious conspiracy now? When does this web that the government's weaving start doing what communism does and touching journalists? Because quite frankly, correct me if I'm wrong, but the only plan that was disseminated amongst the Proud Boys prior to January 6th for January 6th was a 1776 returns document, which
they didn't even promulgate that. That was not a Proud Boys plan. That was created by somebody else.
The FBI.
Right. No, it's sent to Enrique. It was never distributed. It was never acted upon. It was not the plan. It's not what happened on January 6th.
Let's roll it back. Tell us exactly about this document, how it surfaced amongst the defense or in the courtroom, and what does it actually spell out? There was one article written about it by Gateway Pundit that I can see. I didn't write it.
the 17. There is a broad in the United States, and hence the emergence of populism. For many people in the United States, especially people not on the bi-coastal areas, in what's in so-called flyover country, the country is a failed state. We have no control over our borders. We have no ability to forecast a better future for our children. Agnes Deaton and his wife Ann Case have written a book called Deaths of Despair, which came out in 2020 and was ignored when the mostly peaceful protests erupted across the country. But what they found is that white working class deaths are increasing and helping to drive down life expectancy in the United States. And that's because in many parts of the country, older white people, especially older white males, are killing themselves out of a sense of loss of community. They don't feel that they have a stake in their community and an ability to survive. So deaths related to out and out suicide or to drinking or to narcotics abuse are going through the roof. These deaths of despair are real. People are angry, people are agitated, and they're looking for answers, and they're not looking for them from the Democrat Party and the election of Donald Trump. Now, the pandemic arises. People are locked down unless you want to go to an urban barbecue and burn down your local Walmart in the name of racial justice, in which case they'll help bail you out. But everybody else is sitting at home, including a lot of the people who joined the Proud Boys, and they're afraid to go downtown. They're afraid they're losing control of their communities. And President Trump mentions them in a debate with Chris Wallace and Joe Biden. And he tells them to stand back and stand by, or words to stand down and stand by, or something to that effect, after Wallace called them white supremacists. And, these guys are not white supremacists. That's a failed narrative. If you happen to be white, you happen to be male, and you don't like the direction this country is
Let's
moving,
face it,
that
white
doesn't make you a
supremacy
white
is synonymous with patriotism at this point, according to the DOJ.
Who knows what those clowns are up to? But in any case, we get to, we get to the summer, or we get to J6, and suddenly we're all, now we've got absentee ballots everywhere because you got to stay home unless you're protesting. And we're told they appear to be. There's likely to be a report on election night, and days and weeks later, the absentee ballots could sway it. And they did. Now, I'm not aware of systemic fraud that would have changed the election results. And there were 60 some court cases that had an opportunity to prove that case, and they failed. Many people believe, however, that the election was stolen. And what I think that belief reflects is a belief that the country's been stolen, that the elites are moving us in a direction that is unsustainable and that we don't want to go in. And so people appeared on January 6th angry and prepared to act up and act out. And some of them take their country back. That doesn't make them revolutionaries, at least not yet. It makes them every bit activist, as much of an activist as the BLM crowd was after the Floyd death in 2020, as much as the labor movement was in the 1890s, as much as the Wobblies were in the area of the Red Scare, as much as the New Left was in the 1960s. America has always been a country of people with violent opinions violently in contrast with one another. And the genius of American life has been that we've been able to make something of it. And we make something of it by coming together to oppose a government that imposes too many restrictions on the ability of any one group to speak out or act out. Because what we realize is that in speaking out and acting out, we create a sense of community. Except now, if you happen to be a white male or a white middle-aged person, you're presumptively suspect.
Well,
Because
we have
after all,
Jamal Brown, who obstructed an official proceeding, albeit he's a member of Congress, so he's a Democrat member of Congress, so he's above the law. Then we have the pro-Hamas demonstrators obstructing official proceeding while the new House Speaker is getting a vote, and no 1512 ratings by the FBI, nothing. So it's clear that this is about speech crimes, and you commit speech crimes when you are a particular demographic. And it just so happens, Norm, that 80% of these J6 defendants are veterans. I find that ominous, considering, a combat veteran wouldn't take their guns, their firearms, all of their years of training to insurrect. They just go with pepper spray and an axe handle. Not a blade. War.
In the mid-19th century, 600,000 Americans lost their lives in a sectional conflict where we killed brother brothers, killed brothers, and we tore the country apart, burned significant portions of it down, and engaged in wholesale violence and slaughter visions of what was good for America. 3 years after that war was ended, we had repatriated almost every participant in the Civil War and went about the business of nation building. 3+ years after January 6th, we're still prosecuting people for misdemeanors and putting them in prison for participating in an event that lasted some 6 hours. It is just totally disproportionate, totally ridiculous. On the topic of speech crimes, let me pivot to Owen Schroyer's case, because I think Owen's case is significant in ways that a lot of people don't recognize. Owen attended an impeachment hearing conducted by Jerry Nadler in 2019, and he disrupted that hearing. He was arrested and charged with an offense. I don't recall the offense. He got what's called a pretrial diversionary program, which it meant that if he completed some community service and didn't violate the law again, the charge against him would be dismissed. COVID struck. He had difficulty finding a place to do his community service, but ultimately he completed it. And in February of 2021, shortly after January 6th, we sent a letter to prosecutors saying, here's proof that Mr. Schroyer completed his community service. We'd like our dismissal. They said, oh no, you miscalculated the hours by, he's 2 hours short. Owen went out and did some more. And then what's more, they for January 6th. We filed a motion to dismiss in the underlying charge relating to Nadler on the grounds the government's refusal to do so was vindictive, that they were welshing on the argument. That was tabled once Owen was arrested for J6. What he was arrested for was effectively trespass, and so he pled guilty to that because he was on Capitol grounds in a restricted area. The pre-sentence report officer in Owen's case called for probation, no time. The government wanted 120 days. Judge Kelly gave him 60, hence halfway Kelly again. Now, we at the sentencing hearing were stunned by the government's reaction to Owen. He had engaged in misinformation. He questioned the election results. He encouraged people in the months prior to January 6th to attend protests. And my response to that was, yeah, so what? He had every right to do that. The government said no, and what's more, after January 6th, he wasn't remorseful. He continued to spread disinformation. This is in their papers. So I said to Judge Kelly, this is protected speech. It's not like the Proud Boys case where you can use their speech as circumstantial evidence of their desire to use force against the government. It's a trespassing charge, and you're criminalizing his speech. The judge disagreed and sentenced Owen. We asked the judge to let Owen remain at liberty while we took an appeal. He said no. We went to the DC appellate court, asked them the same thing. They said no. So now now Owen is in prison. I was down with him in Louisiana in Oakdale last week to turn him in, and he will be in solitary confinement until tomorrow, ostensibly because of COVID regulations. And we will continue with his appeal because people have said several things, and I want to correct this because the mainstream media, legacy media, continues to get this wrong. Mr. Schroyer did complete his community service, period. Even the government acknowledged that at the sentencing hearing. So if you're continuing to spread that lie, get over it. Mr. Schroyer will remain in custody even when he's free because he's going to be for 1 year subject to effectively probation. And so we are going to take his appeal to the United States Supreme Court if we have to, because our view is that Judge Kelly erred by considering protected speech as relevant defense conduct. If Mr. Schroyer spread disinformation, that's not a crime. There's no licensure requirement for journalists, and we don't need the government's permission to speak. So the notion that Owen was punished for his speech sits very heavily on my mind, and it should sit very heavily on the minds of all of your viewers. This is a case that must be fought, because if you're guilty of speech, bad speech, and it can be used to enhance your sentence for trespassing, what does that mean? Does that mean that if there's any arrest of you, it can be a pretext for punishing you for your thoughts and for your speech? And right now the door is ajar to that, and we need to make sure that it doesn't open any further.
It's absolutely absurd. I mean, I would argue the Proud Boys too also just being prosecuted for speech crimes? Or what is seditious conspiracy anyway, for that matter? I wonder, do you have the answer to when the FISA court issued surveillance warrants on the Proud Boys? Because there are former members of the Proud Boys who said the FBI was running up, trying to infiltrate their groups way before January 6th, years before January 6th. And of course, there's all of these confidential human sources. And again, back to the 1776 returns document.
Yeah, I forgot it. Yeah, so
Yeah,
you asked
let's
me
talk about that
minute
first.
ago,
I mean,
and
to
I went
address
about
the
15
CHSs.
detours. So so apropos the great tension in the country and the legitimacy crisis that I was talking about, plenty of people wondered what would happen in the 2020 election. Would there be a peaceful transfer? War gamed this, and they thought, what could go wrong? I believe the 1776 document is a product of one of those gaming experiments. And so what it held is there could be a group of people who come to Washington and engage in simultaneous protests around the city and take over certain Capitol buildings, but not the United States Capitol. So apparently a woman that Mr. Tario had a romantic interest acquired a copy of this from someone. She sent it to Enrique. And Enrique looked at it, but there's no evidence that. Actually, I think the evidence is unclear. I'm not even sure the evidence. Enrique received it, but I'm not sure he looked at it. There is certainly no evidence that it was distributed among the Proud Boys. And if you look at the particulars of what the so-called plan called for, as opposed to what happened, they don't resemble one another. And so the notion that the 1776 document was a master plan the Proud Boys executed is, to use a barnyard term, bullshit. There's no evidence to support it, and the government didn't argue it at closing arguments.
Norm, what do you make of this sedition hunters operation? Are you aware of it? Because there's a swath of online sleuths, they call themselves, and they've compiled massive databases of J6 footage, maps of everyone that attended the Capitol. And I know from working on J6 cases, it's a struggle to get these exhibits and transcripts and motions. Perhaps they have their court reporters paid for and they're doing a diligent job of all of this. Have you dealt with sedition hunters while representing any of these J6 defendants? Have they tried to threaten, dox, interrogate, harass you, as they have me and many others who just call the January 6ers political prisoners?
If they do, I don't notice. I mean, after representing Alex Jones and just being a criminal defense lawyer for 30 some years, I've acquired a legion of haters. And so I just deal with them with humor. The other day, somebody wrote me, said, I hope you get ass cancer. I wrote him back, said, why would I want ass cancer when I have you? Somebody else said, how do you sleep at night? I wrote back saying, I count morons. You're number 127. Next question. Somebody else said, you're such a loser. And I'm like, well, I get invited to give keynote speeches at Mensa conferences. I didn't see you there. So I ignore the haters. I think that they are mobilized to suppress people whose views differ from their own, and they are the neo-fascists, and they are the authoritarians.
Well, they're also they're FBI informants, and it's been alleged that they're government contractors. I'm just curious if you know anything about this. I'm sure you got your hands full, but...
Anybody can be a government informant. I mean, basically, the FBI has a program where they can register confidential human sources. And I've got the guidelines here. I probably can't find them while we're talking. But if you call the FBI and you say you have information, they will vet you, and they will determine whether you are to be trusted, whether they can trust you, whether you have information they need. You'll be given a registration number and a handler, and then they will manage you while you are infiltrating whatever group you're a part of. And so most of these people are walk-ins from the world at large. They go to the FBI looking to get something from the FBI. Some of them get paid. Some of them have motives all their own that may be patriotism. So I suspect, with respect to groups like sedition hunters, that they are motivated, and that there are members of many right-wing groups who are in fact there only to serve the interest of government. They've decided that a group like the Proud Boys, for example, is a dangerous group. They'll pretend to be a member and then report on the Proud Boys. And one of the most interesting things that happened in the Proud Boys trial was we finally got some evidence through confidential human sources. And the senior Justice Department lawyer came to me one evening and said, what are you trying to do here? And I said, well, what I want to know how many confidential informants there were in the Proud Boys. from November through the January 6th event. And, there were six FBI agents assigned to the Proud Boys trial. And we've been cycling through the agents as they got on the stand to try to get information like this. This lawyer told me that none of them know. I said, well, how can, I said, I doubt that. And I don't think a jury is going to believe it. And if none of them know, then find me the official who does. Because if these are registered informants, they have numbers, there are files somewhere, and there is a discrete answer. They're not like grains of sand in the universe. There'd be a discrete answer to that too, but good luck finding it. But there can't be that many CHSs. And so we went back and forth, and we were offered a stipulation. The government stipulated that there were at least 8 confidential informants in the Proud Boys. And they would agree that we could tell the jury that if we took our foot off the gas and agreed not to pursue it any further. So I was there to represent Joe Biggs. That served his interest, and I did take my foot off the gas. I don't regret it now, but I know there's a lot more gas in that tank, and we're getting ready to file a Freedom of Information request to get more information. We expect the FBI will fight it, and then we'll take it to court. It's my belief that there is a vast network of confidential human sources, whether that's part of sedition hunters and others, it wouldn't surprise me, whose goal is to weaponize government and to use government to silence dissent. And if you're to the right of the ideological spectrum, you're their enemy. If they're to the, and you need to reckon with that. You just need to accept that.
Well, as far as the FBI gaining the trust of the confidential human source, they all appear to have these very troubled, broken backgrounds and extensive criminal histories. And I wouldn't say Jeremy Bertino, the Proud Boys member who took the plea deal, is a confidential human source, but it appears he's gaining lucratively from pleading guilty. And look at Ray Epps. But Ray Epps is an alleged pedophile who raped his stepdaughter. And then there's just a long history. It's already been documented by several publications how the FBI goes after these troubled individuals to make them confidential human sources. And they're not getting the best of the best here. They're preying on criminals to do their dirty work. Is that your understanding of this to any degree?
It's funny we should be having this discussion because just this afternoon, I'm preparing to file in the United States Supreme Court another writ of certiorari designed to require judges evaluating search warrants to ask more questions about confidential informants. But it's my understanding, and I don't have a comprehensive understanding what the FBI does, but my sense is it's a two-way street. If you're getting a little bit of trouble with the law, the FBI will come to you perhaps and say you can help yourself out by helping us, and we'll give you favorable consideration in the end. Sometimes people go to the FBI for ideological reasons. So with respect to sedition hunters, I suspect some of them have agreed to pretend to be members of the right in order to get information to give the FBI, and the FBI is happy to get it. I suspect that in some instances, troubled souls go to the FBI looking for benefits. So I don't want to generalize. I think it's the good ship lollipop, and there are lots of twisted rooms down that corridor.
If you had to describe, of course, it's kind of mainstream, this term Fedsurrection. But when you look at the role of confidential human sources and Antifa appear to be above the law, I don't understand how was the government picking and choosing which ones are the violent felons, jihadists,
of course they do. Yeah,
terrorists.
That's a prosecutor's discretion. A prosecutor gets to select what charges to bring, and they get to select who to prosecute and how hard to go after each one. And arguably, it's not supposed to be a political decision, but the J6 cases are so obviously political. I for one, have lost respect for the Justice Department.
What's the next step towards preventing the government from giving the Proud Boys more time? Is that something that's going to actually happen? Do you think we're going to win these appeals with the same kind of mob ruled activist judges who have rubber stamped the stolen election? If many of us paying attention that night, including your clients, and that's why they started Stop the Steal, we saw the mathematical improbability where Joe Biden was not elected, yet these courts continued to allow that stolen and fraudulent election to stand. Why do you have faith in the judiciary at this point to turn it around through appeals, or even the Supreme Court for that matter?
I have limited faith in the courts to get it right, but I'm a lawyer and I have enough faith to think it's worth the effort. And I believe that, as bad as things have become in this country, the courts are still open and you still have a fighting chance at justice. So while I passionately disagree with many of Judge Kelly's rulings in the Proud Boy trial, I know that I have a right to take an appeal to the D.C. Circuit Court of Appeals, and I'll get a 3-judge panel there. And if I'm not satisfied, I'll file a writ of certiorari and ask, to the United States Supreme Court to hear their case. And I do intend to raise certain First Amendment issues on behalf of the Proud Boys. I also intend to raise questions about the so-called tools theory in this case. There was a view that some individuals weren't conspirators, but they were tools of the Proud Boys, and the Proud Boys were responsible for their actions. Again, in the context of a riot, that transforms the government's proof, and that's not the law of conspiracy. It's overbroad. I also want the Supreme Court to consider whether, in the context of political speech, it's enough simply to say that a person's speech prior to an event is circumstantial evidence of their intent on the event. I think more needs to be done to protect political activists and to protect core political speech, which is in the heartland of the First Amendment. So do I have faith? Limited. But if I didn't have faith in the courts, I wouldn't be a lawyer. And if I couldn't be a lawyer, what would I do to build a better world? I don't know. I don't know that I would be prepared to engage in violence. I don't think we've come to that point in the country, at least not yet. I'd prefer to live the rest of my life without going to prison. So I have some confidence in the system, but it diminishes exponentially each year.
Members of Congress, they read the Gateway Pundit. Why, if you had a message to deliver to them, as they sit across the street and turn a blind eye to everything happening at the federal courthouse, what point would you like to get across to our members?
How about cutting funding to the Department of Justice? Right? We've got a new Speaker of the House. And we've got an energized Republican Party that has control of that House, and that's where the power of the purse resides. So why not turn the tables on defund the police? Why don't we defund the Justice Department for 6 months to a year and see whether the Republic is any worse off for it? Stop locking people up for protesting about a failed state in the United States. Stop authorizing the Justice Department to infiltrate conservative Roman Catholics or school boards, and start listening to the American people. The Justice Department has become a political tool. I was very, very disappointed in the weaponization of the government committee headed by Jim Jordan. At a time when we were having hearings in the Proud Boys cases and the lawyers were ordered not to disclose what information they had been given, there were hearings going on in Congress. Why didn't any congressman subpoena a lawyer to go to Congress and say, what is it you've been given? What is it you've been ordered not to speak? Now that would have created a tremendous separation of powers issue. A lawyer, as an officer of the court, would have been obliged to obey the court order, but he might have had to obey that court order at the expense of a contempt citation from Congress. They simply didn't try hard enough to get answers. And I had the impression that a lot of them were pretending and posturing for the polls. So I guess what I would say is, if you believe that something foul is taking place in the country, then act like it. You've been elected to lead. You have the power to lead. How about stopping appropriations to the Justice Department until after the 2024 election? We saw the disinformation hoax with respect to Russian interference. We saw leading intelligence figures cover for Hunter Biden and Joe Biden. We've seen the J6 committee or the J6 prosecutions used to decimate the left. We see a series of decisions designed to demonize patriotic Americans for the color of their skin. This has all come from a Justice Department that's coming to look as foul as anything that J. Edgar Hoover did to Martin Luther King. And it reminds me of the period that led up to the assassination of John F. Kennedy. We had an intelligence community that was out of control, and it took a decade or more to get it in control. Congress, if you're listening, defund the Justice Department.
Talk about the plight of the defense attorney in District of Columbia, Norm. I remember we were all sitting on the edge of our seats wondering if you will even be allowed to represent Joe Biggs because the judge in Connecticut wanted to bar you I didn't really understand what was happening there, but somehow Judge Kelly had the grace and everyone filed the paperwork correctly for you to stay on the case. And it looks
Well,
like
so
another way to just, on top of the fact it's so expensive to why is it so expensive to represent your clients on these cases? And what do you need to win?
so the disbarment issue first. I represented Alex Jones in the Sandy Hook defamation trial in Connecticut. I've represented Jones. It'll be 5 years in a couple months. And Mr. Jones was defaulted by Judge Barbara Bellis for failure to comply with discovery. We disagreed with that decision, but that's, she wears the robe, we don't. We fought her on it, and we fought her on a series of other decisions. At his trial in Connecticut, it was a hearing in damages. The court made a series of rulings limiting what he could do to defend himself. And not surprisingly, as a result, he ended up with a catastrophic judgment against him, and we're fighting that. Toward the end of trial, Alex also had pending in the District of Texas another case arising from Sandy Hook. These people had moved to Texas and sued him there. He had a counsel in that case who was working together with me to defend him. And I gave that counsel records in the Connecticut Sandy Hook case that included records involving the plaintiffs. There was a court order that that information not be displayed or given out to unauthorized parties. I took the position that co-counsel or counsel in a related case on identical issues was not covered by that order. The court disagreed. As it turns out, that lawyer's office mistakenly released medical records to the other side in the text, and that created a huge shitstorm. The Connecticut judge read about it. She ordered a show cause hearing as to why I should not be disciplined. I took the fifth at that hearing for reasons that had to do with the strategy of the case and the possibility that I could be accused of somehow maliciously distributing medical records, confidential medical records. Ultimately, she decided to disbar me as a threat to the public for 6 months. We took an appeal of that. That disbarment decision took place right on the eve of the Proud Boys case beginning, and Judge Kelly wasn't sure whether I could work in D.C. if this happened. So there was a very tense period of 8 or 9 days before we were able to get her order stayed by the Connecticut Appellate Court. We'll argue that appeal later this year, early next year, and then we'll get a final decision. We'll get a final decision next year. So I don't think it had anything to do with the Proud Boys or the right. I think this was a judge who had her own agenda in that case. I challenged her authority. I thought to recuse her. I thought to disqualify her. I challenged her every step of the way. I questioned her judgment, even her competence. And, had she held me in contempt, I probably would have said, "You're right, I am." But to suspend me, that was a bridge too far. And so I don't think it had anything to do with the Proud Boys per se. In the end, I think Judge Kelly was wise to let me continue to represent them. There would have been real issues as to the Sixth Amendment right to counsel had he not done so. As to the expense of these cases, I operate an office with about 10 people in it, all of whom have to get paid, and each fight that we're engaged in is a fight to the death for someone. And I like to tell my clients, when you're with me, you've got 100% of my attention, and they love to hear that. But they don't realize the corollary is when I'm with somebody else, they're getting none of mine. And that's my office's job. And so in the Proud Boys case, we went to a trial that was expected to last 4 or 5 weeks. It lasted 5.5 months. I'm living in an Airbnb. I still have the same expenses that I need to cover, on a weekly, monthly basis here in Connecticut. I still have other clients to serve, other work to do. And I was told that there'd be crowdsourcing financing for the Proud Boys case. But as the case unfolded, I didn't even make enough to cover my Airbnb and travel expenses. And so it was an enormous.
Of course, there's 5 defendants that you have to crowdsource fund for at the same time. I mean, why is it even 5 defendants being tried like this when one of the defendants wasn't there? One defendant didn't know the others until trial started, and the other 3 basically committed non-violent crimes. It was trespassed.
It was a wild trial, and I would do it all over again. I don't regret it for a moment. I had a front row seat at history. I wondered what was going on. I remember the day of January 6th. I was working at home. I was writing a brief, and a friend of mine called. He said, "Turn on your television. There's a coup going on in Washington." I said, "Seriously?" I said, "Are there tanks? Did somebody take possession of the Capitol? Did they take possession of the airwaves? Has an alternative government been, declared?" No, 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 no. I said, "It's no coup." I turned on the television. I saw some guys climbing on the side of the building, and I turned it off. I figured it was just a riot, and it would be quelled and over soon, and it was. So I forgot the question now. So I mean, that was my reaction to January 6th, than it is now. But I was asked to get involved in the case, and I thought, I want to know what's going on in this country. Representing Alex Jones has been an honor because he's very much hated in Connecticut. He'd raised questions about whether and asserted that the Sandy Hook shootings were a hoax. I know they weren't. I mean, I had a friend who lost a child there, and so it's real. I live not far from the Sandy Hook Elementary School, but I understand the instinct of people to say, wait a minute, they're going to use this crisis to try to deprive people of the right to bear arms, and the right to bear arms is one means by which we have the inherent power to make government worry about what we'll do next, which I think is an important thing. So I was happy to represent Alex. I wonder, in the course of traveling down to Austin, Texas, because I'd spent many months down there over the course of 3-4 years, I got to learn about his viewers. And his viewers are people who are suspicious of the mainstream media, suspicious of the narrative that the left sells, that diversity is good for, in and of itself, that we don't know the difference between men and women, that we need somehow to subscribe to global norms and start eating grasshoppers, and pretty soon we'll own nothing and be happy.
That is their agenda.
Yeah, plenty of people are like, hell no, I'm not going there. And if you look at the books Alex has written, he's got another one that's coming out any day now. He's not a Sandy Hook conspiracy theorist. He's a person who says ordinary people are pissed off and they're not going to take it anymore. And I figured those might have been the people that went to January 6th, and I wanted to the event, and I wanted to know more about them. So I was thrilled to get this trial. And here's what I learned: Joe Biggs, Zach Rell, Enrique Terrio, Ethan Nordine, Dominic Pizzola. These are men that I admire, that I respect, and that I would defend all over again, any day of the week, in front of anyone for anything. Because as far as I'm concerned, they're the salt of the earth, and the government's decision to prosecute them is obscene.
This is the most important free speech case in American history, in my view, and I will continue to report on this and uncover all of it until they go home, Norm. I'm committed to this till they go home. To me, sitting in that courtroom is like watching people get tied to a tree, taped across the mouth, and sliced with 1,000 paper cuts for thinking the wrong way. Again, much of this seditious conspiracy lies in your Telegram chats.
Well, but again, Alicia, I'd never defended a seditious conspiracy charge before.
When's the last time someone had?
But if you think about this definition of seditious conspiracy, it's a little scary. And a conspiracy is two or more people agreeing to do something unlawful. Sedition is using force against the authority of the United States government. That's all it is. And so seditious conspiracy could be going to the Capitol and breaking a window if your intent in doing so is to stop Congress from acting. That in and of itself is sedition. Now, conspiracy means agreeing to do so beforehand. And I do not believe that there was an agreement to do anything of the sort beforehand. As I said before, I think there was a riot that erupted spontaneously, and these guys got caught up in it. And, should they have been penalized for that? Sure. Break into my building. You're going to get.
When was that the same as mass casualties, deaths, killing people, murder?
No,
I don't know.
That was the terrorism enhancement. That was actually pretty amazing. I mean, funny in a dark humor kind of way. So at sentencing, the government seeks to double their sentences by having them under the guidelines declared as terrorists. So there are 47 statutes that satisfy the definition of terrorism. Mass destruction, using a nuclear weapon, downing an airliner, big things that, they sound pretty terroristic to me. And then another one was destruction of government property. And that's all. And so in this case, a fence worth about $32,000 was destroyed. And this was the government property that Judge Kelly found was sufficient to qualify these men as terrorists within the meaning of federal sentencing law. It's ridiculous, and it's not what Congress had in mind at all. When government has the ability to pick and choose and to conduct within broad definitions like that, and hurt some people rather than others because of the content of their ideas, we've lost something fundamental in this country.
Well, I think our country's already lost based on what's been happening here, and we have to fight for it to bring it back, to resuscitate our constitutional
Amen.
rights.
Amen.
Norm, tell us where we can support your endeavors to win these lawsuits and win these appeals, and all the way up to the Supreme Court. You have several defendants that you're working with on January 6 cases.
Yeah, so I
go to all their gives and goes, but what's the best way to support?
With respect to Owen, there's an Owen Schroyer Defense Fund on Give Send Go. I would encourage people to contribute there. I've begun to work with a group called Condemned USA. They created a web page or a Give Send Go page called the Pattis Freedom Fund. These are not cases that are lucrative. They are cases you take because they're the right thing to do, but the expenses of running a law firm continue to be real. So again, if you want to contribute to the Pattis Freedom Fund, that would be great. That's, I contributed that to Condemned USA. They've done a wonderful job supporting J6 defendants. And then Owen has his own page, the Owen Schroyer Defense Fund. That will benefit the firm as well. I really appreciate your support if you think about it.
I'm grateful for the support of the Gateway Pundit readers. In fact, this publication has garnered more donations for January 6 defendants than any other entity so far. Wow. And does the best job, I would say, at least by covering all the as many J6
Well, I'll say this, Alicia. There were very few people who were at trial every day from the press. You were one of them. And, I avoided you during trial. I hope you weren't offended, but I was really mindful. Coming into trial with another judge having disbarred me, I had to be on my best behavior with Judge Kelly. And the result is I bit down so hard, I probably chipped a tooth or two.
You've been most gracious, especially I'm going to fight to get to the bottom of things. And so I'm going to just, like I said, be a rock in your shoe. And finally, we have a chance to sit down and talk. And I'm grateful. Thank you for being so gracious, giving us almost a full hour of your time. And I hope we can follow up as these cases move along, because
I
truly,
hope so too.
You attorneys have all the answers that we need and more.
No, we don't. We totally should. That's the thing. The problem is, if Immanuel Kant, an 18th century philosopher, once said that two things fill them with wonder: the starry heavens above, like the vastness of the universe, and the moral law within. Like, how do I have this sense of right and wrong that guides me? I'd say a third thing fills me with wonder, and that's the fact of government. We've got 350 million people wandering around the United States, and somehow we all have settled expectations. We want to live together peacefully. It's a mystery how that happens. And right now, that mystery is up for grabs. And we're on the cusp of violence in a failed state, in my view, verging towards something like civil war. I don't have answers to create peace. I do have a commitment to the rule of law and to the notion that courts are where we should go to resolve these fundamental disputes. When I lose confidence in the courts, I get worried. I get worried about the country, and I am worried about the country. But it's still worth fighting for, Alicia, and we need to come back to court. We need to hold power accountable, and we need to keep screaming and fight for our right to be heard.
Absolutely. Thank you, Norm. I'll be seeing you in court again soon, I'm sure. And
I hope so.
God bless.
Thanks, Alicia. Be well. Thank you for having me. Thank you, everyone.
Thank you.